Where are you getting all the money? Because you come to court with a T-shirt in a T-shirt. It just shows you don't really have much respect for the whole process. You don't have respect for the law, but it shows you don't have respect for it. You come in with a T-shirt and you're looking at up to life in prison, and then you got a $50,000 bond. You think we're not serious about that?
No, sir, I never said it, Your Honor.
Yeah, well, that doesn't impress me. It's you apologize, but it's the point being is you come in. That was what you got up and thought this is the right choice to make, and that's not. It's a poor choice, but you had a series of poor choices. I'm looking at 15 arrests on Aaron Hall and Shannon Simon.
Oh gosh.
Did she trip over the leg thing?
I didn't see. No, Rita.
Sit down, please. Thank you, ma'am. Sit down, please. Thank you. Revoked, you can be found guilty and sentenced to no less than 180 days up to 2 years in the state jail for each case. Knowing that, do you insist on pleading through today? Yes, sir. I find you.
Today we are joining Judge Stevens' courtroom in the heart of Texas, where justice is served with no nonsense and authority. In today's video, we have two classic cases that showcase the unique challenges the judge faces in maintaining order. In the first case, a defendant raises eyebrows when he appears in court wearing a simple white t-shirt, seemingly oblivious to the serious consequences he might be facing. Judge Stevens took it as straight-up disrespect to him and the court. In the second case, the courtroom witnesses an unexpected and dramatic moment when a lady experiences a major accident, falling face first. The scene unfolds in a way that would rattle most courtrooms, but not Judge Stevens. He remains focused and composed, continuing with the docket as if nothing happened. Share your thoughts in the comments on how you think Judge Stevens handled this situation. And stay.
It looks like your attorneys at the beginning, I think you were appointed a public defender Dusler. And then shortly thereafter, you hired Mr. Faggart. Is that about right?
Yes, Your Honor.
So that was, looks like about Mr. Faggart sends us something on early of August of 2021. But you're not satisfied with that, you go out and get arrested again, don't you? For cocaine. And so now you've got two cases, 23-41640. You've got a third-degree felony of evading arrest and a second-degree felony of illegal possession of controlled substance. Correct. You see anything wrong with that? What? Yeah. What did you on the controlled substance back in 07? What was your sentence then? It was in this court. You remember?
I think it was like.
But wait. You don't even remember.
No, I do.
Something as important as going to dealing with a felony offense in your life. You can't even really recall what your sentence was.
I apologize. I do. It was 3. I was wondering what you talking about my 1244 day. I didn't know which one you were talking about. My bad. So I had got a 3 when I was in Tennessee.
So you get 3 back then. Now you pick up 2 more cases and you're going to get 4.
I mean,
come on, guys. Really? I mean, he comes out of prison and evades arrest. and then gets arrested on bond, then later on gets picked up for. I mean, you're incorrigible. I mean, we're just slapping your hand. I mean, you're looking at on, correct me if I'm wrong, folks, right? You're looking at 41640 up to life in prison. Right? 5 to, yeah.
Yes, sir.
No, I'm not gonna do that. That's not what I'm gonna do. I'm not gonna do it. I mean, that sets a bad example for everybody else. Okay, we'll just roll it around. Let you. He's not eligible for probation. He's looking at 5, a minimum of 5 in front of the jury. So
May I ask
that's the way
you
it
for a
is.
reset so I can?
Yeah, you bet. Yeah, you got. But we're gonna just put on a trial now. Okay, just get a reset. What's in it? What was his bond? Just $15,000. He's got 15
20,000 on
arrests.
the possession case.
Yeah.
And it was 30,000 on the evading arrest.
So you posted a $50,000 bond. Huh?
So,
Yeah. Where are you getting all the money? Because you come to court with a T-shirt in a T-shirt. It just shows you don't really have much respect for the whole process. You don't have respect for the law, but it shows you don't have respect for it. You come in with a T-shirt and you're looking at up to life in prison, and then you got a $50,000 bond. You think we're not serious about that?
no, sir, I never said that, Your Honor.
Yeah, well, that doesn't impress me. It's you can apologize, but the point being is you come in, that was what you got up and thought this is the right choice to make, and that's not. It's a poor choice, but you've had a series of poor choices. I'm looking at 15 arrests. My goodness, I'm not surprised.
She's gonna email us a reset.
Carla Culver, that's you?
Yes.
Right here, please. Thank you. 23 CR 1647 is called Carla Culver, who is present with Ms. Mantalini, your attorney and the state's attorney, and you are Carla Culver.
Yes,
Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in sum?
yes, sir.
In summary, this indictment states that on or about September 29, 2023 in Jefferson County, Texas, you committed the second-degree felony of aggravated assault causing serious bodily injury. And raise your right hand. Do you solemnly swear or affirm all statements that you make during these proceedings will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand. Is that, do you understand what you're charged with here?
Yes, sir.
If convicted of this second-degree felony, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes.
An agreement's been reached for you to be pleading guilty, sentenced to whatever sentence shall not exceed a cap of 7 years. So you were looking at no less than 2 nor more than 7 years confinement in prison. You are looking at up to 7 years in prison, no less than 2 nor more than 7 years confinement in prison, and that can be suspended and you can be placed on probation for up to 10 years.
Okay.
And finally, can I place her on regular probation for this? Because that looks like a deadly weapon was used by so I can't put her on regular
Between the serious
probation.
bodily injury and the
Yeah, deadly weapon, namely a vehicle, was used. So
only deferred. I
only
believe.
deferred is the only option for probation, which you could be placed on deferred or unadjudicated probation for up to 10 years in length. And is that your understanding of the options?
Yes, sir.
So you were looking then at whatever punishment shall not exceed a cap of 7 years in prison. If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this offense charging you with the second-degree felony of aggravated assault? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? Did you say something?
Yes, sir. She also is asking the court to consider releasing her in this interim period on a personal recognizance bond. She's not able to post bond. And she does have family here in the courtroom and has a place to be during this time period. And if the judge were to release you on that sort of bond, would you or your family be sure that you get to probation to do the report?
Yes, ma'am.
And the interview that they need to do?
Yes, ma'am.
And back in court
Yes,
on the
ma'am.
date that you're told?
Yes, ma'am.
All right, what's her bond right now? You say it's too much. What is it?
I would thought you were asking your clerk. What, how much is your bond?
20,000.
I knew it was low, Steve low. That's why she's still unable to make a $20,000 bond.
What's the state saying?
Based on the seriousness of the charge, Judge, I would object to a personal recognizance bond.
He's objecting to that. The state's objecting to it. I'm reading, bond is based upon not only criminal history. I don't know of any criminal history she has. I don't. State may know of it.
She does. She's had a misdemeanor probation so far that I've seen that was revoked, Judge.
Okay, well, the terms and conditions of probation are similar to what bond conditions. If she failed to, if she has a history of failing to follow probation order conditions, then the bond conditions are essentially the same thing. But I'm looking at this probable cause affidavit, and this is in the indictment here, which states that you used a vehicle to crush someone's legs.
My understanding is the victim is still undergoing medical treatment.
And also, although
This serious bodily injury was called by the use of a vehicle, which is a deadly weapon in its very definition, the way the indictment is alleging, because it is a vehicle in its use, the way it was used, is capable of causing serious bodily injury or death. That's the way it's been indicted, serious bodily injury.
yes,
I'm disallowing your request at this time. I find that the bond is kind of low anyway. So that's the way it is. That's what it will be. But we're going to get this set for sentencing hearing here in a few weeks. Okay, that's all we can do. Thank you.
Need to get her thumbprint.
She needs a thumbprint over here. Aaron Hall.
Your Honor, everybody's been in the other holding cell this morning.
Sean
And I just
Simon.
wanted to double check with Mr. Hobbs, Shan Simon also, as far as I know. He's, I believe doctors found him incompetent. We'll have that this morning.
Okay, I don't know that, but you're going to go find out for me.
I don't know, find out what.
All on Aaron Hall and Shan Simon.
Oh, gosh.
Did she trip over the leg thing?
I don't know. I didn't see.
No, Rita.
Sit down, please. Thank you, ma'am. Sit down, please. Thank you.
Yeah.
No, Shan Simon, doctor did already find him incompetent, so we'll do that this morning.
Yeah,
And then Mr. Hall, I believe we're gonna have to request a hearing in his case,
a what?
a hearing on his MTRP.
Okay. Okay. Let me.
After
give me
talking
the
with him,
Aaron
unless
Hall
he's changed his mind,
and
I
Simon.
haven't had a chance to re-talk to him again this morning because he's been on the other side of the building. But that's where we left it in our visit. And he's also gonna be requesting the court set a bond on his motion.
Hmm. So she's a,
Sir,
hey, Kevin,
Yes, sir.
on Aaron Hall,
Sir.
it's placed on probation in June of this year.
Yes, sir.
And then on September, committing the offense of resisting arrest. Is that what it's showing?
That's what the officer
Indications.
felt like.
Indications at the time of the
There's
resistance.
no test. and-
Okay, but nobody's got a scientific test to support that, right?
No, sir.
Okay, well, then curfew violation. Didn't complete the theft class. And is in arrears. Okay, do you have a pre-sentence report on that?
I don't have my file. Let me see if I can give them my assistant probation officer is handy and the other judge.
Are you taking over Yvette's load now?
Sir,
Are you taking over Yvette's? load?
temporarily.
Where did I-
Good luck. Well, there's a lot of cases she had, I think.
Who's that?
All right,
Hmm.
oh boy.
So that's where I would ask the court to set it for hearing so that we could prepare. I don't have anything, I do have information on the resisting arrest. I don't know if he's been convicted of public intoxication and got time served on that, or if it's still pending. I think that the biggest problem is that Mr. Hall is, the recommendation is 10 years, and I think he's hoping that with the hearing and the information from probation, even in spite of some of the information in the allegation that brings him before you again today, he's hoping that the court would keep him on probation.
All right, so. It's a second degree. Felony.
All comments, viewpoints, interpretations, and insights expressed in this video are for education and entertainment purposes. All individuals featured in the video are to be presumed innocent until proven guilty in a court of law. Please do not attempt to contact, locate, or engage with any individuals featured in the video.